So today we're here to talk about permanency planning for children of incarcerated parents, and I just wanted to talk a little bit about the background of what we know right now about permanency planning for these children. What we do know about these children is that they are uniquely vulnerable to the permanent loss of their relationship with their parent, and that's really because of the historical impact of changing child welfare policy and changing criminal justice policy. So we saw when ASFA was enacted and established a 15 out of 22 month timeline to reunify, we also were seeing a really dramatic increase in our use of incarceration. And at the same time we were increasing our use of incarceration, we were actually also at the same time making sentences longer. So we were really increasing how long people were going into jail. So more people were going into jail and they were serving longer sentences. Certainly no one set this policy with the intention that children of incarcerated parents should lose their parents at a faster rate than other children in the child welfare system. But the reality is that is what has happened. So this has really created some unique challenges for us, really trying to figure out, is reunification possible for these kids? Getting the families the services that they need within 15 months to get them reunified has been challenging. So Judge Clark, I want to start with you and ask you, how do you deal with some of the permanency planning challenges for children of incarcerated parents?
Well, there are a lot of challenges, and of course you mentioned some of them. One is that the time frames in which dependency cases have to go to hearing, and the judge has to make a decision whether a child is adjudicated dependent or not, are very quick. So if the child has been removed from the care of a parent, we have a 10-day hearing. The wheels in criminal court move much more slowly, so they don't jive with the juvenile procedural rules, and they don't jive with the ASFA time frame. So a number of things that we have to look at are, one, really what is the bond and relationship between the child and the incarcerated parent? So we want to know that up front, so we know, should we really be working towards a permanency goal of reunification? And just to critically analyze, is that really viable in a case? The caseworker, the agency, needs to meet with the parent that's incarcerated, just like they would meet with a parent that's not incarcerated. It can be a little bit more challenging for them to do that because the parent may be incarcerated in a jail or prison that's not within their county, that requires travel. But today, with modern technology, with telephones, video conferencing, they can do it quite easily. So they need to be familiar with what services and programs are available within the correctional facility. So if, for example, there's an issue of domestic violence, but there is not domestic violence counseling in that facility, then they shouldn't make that as part of the family service plan goals, at least not at that time, because they can't do it. So they should find out what's available and ask the mom or dad to work on those services that are available in the facility. They should regularly meet with mom or dad to be updated on any progress, or talk to the counselor or social worker at the jail to make sure that they're in the program, what they're doing, and so forth, and to see how close they are to being released or going to trial. One of the other things that should happen, if they are discharged or transferred from whatever facility they're in, that they are to notify the caseworker within 72 hours of the discharge or transfer. And the reason for that is so that the caseworker knows where they are, so that they can get into contact with them. And if they've been discharged, then the caseworker is to set a meeting up with the parent and then amend the family service plan to reflect the change in their status and to add or change the goals that they need when they're released. And then they should also coordinate with probation or parole so that the goals are consistent, and so that there is not a duplication of services, which we know happens. And sometimes we can overwhelm people with too many obligations and too many services, and when we do that, then they don't do any of them very well.
So we know that ASFA did establish this 15 out of 22 month time frame in which that children in foster care should have their parental rights terminated if they've been in foster care for 15 months, 15 of the last 22 months. But ASFA also established several exceptions to that time frame. So one of the exceptions is the child is living with a relative. Another exception is that there's a compelling reason that termination of parental rights isn't in this child's best interests. And then the third exception is that Children and Youth hasn't provided adequate services to the family. Eleanor, can you talk about how those exceptions may factor into decision making about children of incarcerated parents?
Sure. First of all, we know that we want to use kinship care. And when a parent's incarcerated and that's the main barrier to their acting as a parent day to day, it may well be that the child is in a kinship care arrangement where that kinship caregiver doesn't see themselves as an adoptive parent, and then termination won't be appropriate. The second one I think is so important, and I like the way you stated it. I always think of it as a child-centered, compelling reason why termination of parental rights is not the right choice. Child-centered.
Yes.
And so that's where we really need to be mindful of and focus on what was the relationship of the child with that parent, what is it now, what does the future look like, and keep our focus on the child. And then the third one is really important because, as we've already acknowledged, not every service that a parent might need to achieve their reunification plan is available in the facility where they are.
I think we need to talk a little bit about concurrent planning as part of the permanency plan. What do we do when we know that a parent is not going to get out anytime soon, or we know that many parents go in and come out and go in and come out. So right now, reunification may actually be a viable permanency goal, but if the parent is released and goes back in, it may not continue to be. And if we don't have a plan B, then we can really delay permanence for the children. So, and that's not in their best interest.
We want to support the child's relationship with that parent. So we need to be thinking about whoever that child is living with while the parent's incarcerated. Does that caregiver understand how important the relationship between the parent and the child is? Are they willing to support that now? Are they willing to support it in the future?
It's really important in cases with children of incarcerated parents that we're really front-loading the services and doing all the work right up front so we can make the best possible decision for the child down the road. So what about reentry planning? How do you think about reentry planning? We know a parent is getting ready to get out. How do we kind of approach that in terms of planning for reunification?
Well, I think one of the challenges is that many times we don't know when the parent's going to get out. So, for example, if a parent is incarcerated pre-trial, well, we don't know whether they're going to be convicted or not and how long the trial process is going to take. And probably the best practice for the caseworker to communicate with the probation or parole officer to say, what's the plan going to be when they're discharged, because they may have a really good probation plan that really would satisfy what the agency and wants the parent to do. So they should talk to the probation or parole officer, and then they should assist the parent with helping those services. Ideally, it would be nice to have the services waiting when the parent is discharged. That might not always be possible, but we do know that many inmates are released to a community corrections facility, so they're not completely discharged, and that's really a good time to begin that planning, because while they're in community corrections, then we can be working on issues of housing, continued treatment if they need drug and alcohol treatment, and so forth, and they can be having different types of visitation with their children. The other thing is, you know, some of the best practices that we've been highlighting in Pennsylvania for a number of years now, such as family group decision making and family finding, can really greatly help with the reentry plan. So even in a case where you may have not done family group decision making at the beginning, maybe it would be great to do family group decision making to let the family help with this reentry plan. So I would highly endorse family group decision making as a way to create the discharge plan and help with reentry planning.
What about the parents who have longer sentences, and we know pretty much right up front reunification is not going to be a viable option? Why is it important to plan with those parents still?
Well, first of all, it's important to respect their relationship with their child and their child's relationship with them. So it's reality. We need to be conscious of reality and accept reality. If they're not getting out at a time that they can function day to day as a parent to the child, I think even for those parents who end up having pretty long sentences, what you were saying about front loading is really important, because the more we engage that parent at the beginning, respect their relationship, respect their rights, show them that we are including them in their child's life, the more likely it is that they will help figure out what permanency is going to be for that child.
I think that's huge. I mean, as somebody who represents parents, seeing parents being brought into the decision making about their children right from the beginning really empowers them to make the best possible decisions for their kids, and really respecting that they have their children's best interests at heart and they really do care about and love their kids is really critical to great permanency planning, I think. So can we talk a little bit about termination of parental rights and how we think about that? We know that our courts have said that while incarceration is not a litmus test for termination of parental rights, a lengthy sentence could be a grounds for termination under 2511A. How do you think about planning? Do we pursue termination of parental rights in a case with a child of an incarcerated parent? Do you want to start with?
Well, I think one of the things, and we come back to this again and again, is to evaluate the relationship of the parent and the child. It could be very likely that termination of parental rights, despite the incarceration, is not in the best interest of the child. It does not best serve the needs and welfare of the child. And the court has to make that finding. So grounds alone are not the basis for termination. It's grounds for termination, and termination must serve the needs and welfare of the child. So the court has to find two things. So that's the first thing the court should determine. And then, is there another permanency goal that might be more appropriate than adoption? For example, many of our children in Pennsylvania are in kinship foster care. And so it might be that relatives, while they are willing to take care of the children as long as the children need someone, doesn't matter to them whether they are actually adopting the children. And some of them, quite frankly, don't want to do that. I think that's a hard decision for a relative. So we need to balance that and look at other possible permanency goals and see, is this permanency goal better for this child than adoption? And then even where the court might think that adoption is the best goal, maybe because the child's very young and didn't have a long relationship with a parent, and maybe, yes, it could clearly be the situation where termination might be best for this child. Things like adoption mediation can result in a voluntary relinquishment, which might be better for the parent and for the child, and can result in continued contact of some form between the parent and the child. So I think that's really important. And then just hearing from the children that are old enough to tell you what they want, and hearing from the parent. I think most parents really want to do what's in the best interest of their children, and they know that it's not about them, it's about their children. So including the parent in this whole process about how to making these decisions and giving them choices and making them understand what the children want, and hopefully seeing what's probably in the best interest of the children, really makes the process much better.
Eleanor, how do you bring the role of the individual child into your representation and thinking about permanency planning?
Children need permanency.
Yes.
And they need to know that they have it. It's important to their own sense of identity. It's important to their security day to day. So they do need permanency.
Sure.
And sometimes adoption is the best way to achieve it. So I think it's important that we remember that. I think it's equally important, as you both were acknowledging, adoption is not the only form of permanency that there is, and adoption does not preclude an ongoing relationship with the parent whose rights have been terminated. So whether it ends up being a voluntary termination, or even if it's an involuntary termination, still doesn't mean that the child can no longer have a relationship with that parent. They can.
So our law does say that termination of parental rights is final and irrevocable, and that parents don't have a right to contact in general after TPR. But we have this new provision in our law which provides for post-adoption contact agreements. And do you want to address kind of how those post-adoption contact agreements could help in our planning around children of incarcerated parents?
Well, I mean, I think it could help up front to know, for children and parents to know, that termination of parental rights in adoption doesn't preclude or prevent post-adoption contact. And I think it's important for foster parents to know that they have some say-so in what that contact can look like, and that they would have access to the court if it's not working. For example, if it's not safe, if they believe the contact is not safe. I think that's a concern for foster parents. They automatically want to say no because they're concerned, especially maybe if it was a case of serious mental health instability or addiction, and they don't want a parent that's unstable coming and having contact with the child. And that doesn't mean that they have to. So they have an obligation to keep the child safe. So I think we have to have a good process, mediation process. I highly recommend that the parents' counsel, a lawyer, be present during the mediation, or have some say-so, be able to counsel their client about that, because I think that helps a lot. So I just think it's a great tool to get to permanence for a child earlier, because we want to achieve it as quickly as possible. That's always in the best interest of the child. So in cases where reunification is the goal, then we need to do that quickly.
Yes.
We should not linger. In cases where it's not, and some other goal, including adoption, is what we're working towards, we should do that as quickly as possible.
Kathleen, what are the challenges for the parent in permanency planning for children?
One of my first roles as a parent attorney is to really sit down and counsel my client that, you know, the court process seeks permanency for your child, and here's what permanency means, and here's what some permanency options are for your family. So I think counseling your client is really important. And for my clients that are incarcerated that want to reunify, which is a lot of them desperately want to reunify with their children, there could be a lot of permanency planning challenges on accessing the services they need to get to reunify. I think visits are huge for my clients, and we all know that visitation is the best predictor we have of successful reunification. So we know that my clients don't get as many visits as my clients who are not incarcerated. My incarcerated clients really struggle with getting visits. And so I think as an advocate for parents and permanency planning for parents, it's really important in my role to kind of push for visits and to also push for kind of quality services for the parent. The other big thing that my clients really struggle with is being brought to the table for the actual planning meetings. Our law is very clear that parents have a right to be consulted in the development of their family service plan, but the reality is for incarcerated parents all too often that just doesn't happen. So for me, it's critical that my clients have a voice in what is the plan for my child? What's going on with my child right now? What are we thinking about? You know, what will I need to do if my goal is reunification? It's very hard for them to kind of understand those things if they're not brought to the table.
I think it's really, really important that we keep in mind we have a wide array of choices that we can use so that we make sure that each individual child's best interests and needs are being met.
And what I hear you saying is that best interests of the child have to be paramount, and they have to guide you through the whole process, right? I mean, I think ASFA is very clear that a child should never have a permanency plan that's not in her best interest. The court has a responsibility to kind of be the arbiter of the permanency plan and really consider, is this the permanency plan that is best for this unique individual child?
First, I think we need to focus on front-loading services, making sure that we engage that incarcerated parent from the start, and doing really good concurrent planning, again, from the start.
In considering the best permanency plan for the child, the best interest of the child must be the priority. A child should never have a permanency plan that is not in her best interests. For parent attorneys in counseling your parent, it's critical that you convey to them the ASFA timeline, explain the timeline and how it will affect their case, and also explain the exceptions to the timeline and how those may factor into her case.
It is important to be mindful of the unique impact ASFA timeframes have on children of incarcerated parents. The court should consider in every case whether an exception to the ASFA TPR filing timeframes exist, and also consider what option on the permanency hierarchy best serves the interests of the individual child.
Incarceration may be a factor in the court's determination of whether termination of parental rights is justified, And the length of a parent's sentence is particularly relevant.
Even in cases where an incarcerated parent has a lengthy sentence, the court must still consider whether termination of parental rights best serves a child's needs and welfare. If termination of parental rights is not in the child's best interest, it is not appropriate.